Good morning, everybody, and welcome to this morning's webinar where we shall focus on succession law and estate planning in the Kenyan context. Before we proceed, an introduction as to the firm of Oraro Company and the speakers. So, Oraro Company Advocates is a top-tier full-service law firm. It was established in the year 1977 by George Oraro Senior Counsel, who was one of the foremost litigators in Kenya. And the firm has grown in leaps and bounds since then. Today, we are proud to say that we are a full-service law firm offering a wide spectrum of legal services that range from arbitration, asset tracing, recoveries, banking and finance, capital markets and conveyancing, as well as real estate, corporate and commercial law, employment and labor, fintech, infrastructure and projects, as well as PPP, and of course, most importantly for today, succession law. We have consistently been ranked as a leading law firm in various international directories, such as Chambers Global, IFLR 1000, and Legal 500. We have also recently enhanced our continental presence by way of joining our Pan-African legal network known as AB David Africa, which has a presence in around 24 African jurisdictions. So that's a bit about the law firm. Today, we are excited to have before you a team of 4 speakers, starting with the Honorable Mr. Justice Retired Philip Waki. His CV is rather lengthy, and if I was to go into a lot of detail, it would probably take the entire duration of the presentation. So I shall highly summarize it and say that Justice Waki qualified as a lawyer, having graduated from the University of Nairobi. He qualified in the year 1974 and then went into private practice for a period of around 20 years. He was appointed a judge of the High Court in the year 1995, and thereafter was elevated to serve as a judge of the Court of Appeal in the year 2003. It was the then apex court in Kenyan judiciary hierarchy. Justice Nyamu has also been recognized as a leading jurist, having received the prize of Jurist of the Year by the International Commission of Jurists in the year 2008. He also served as a chairman or member of various committees in the Kenyan judiciary, including being a member of the Rules Committee and served as chair of the Expeditious Disposal of Cases Committee, the Technical Coordination Committee of Governance, the Justice, Law and Order Sector, as well as the Judiciary Transformation Committee, amongst others. In the year 2008, you will all remember that Judge Waki was appointed to chair the commission into the inquiry of Kenya's post-election violence, which is an era that we all remember for the darkness which prevailed then. But it is through his guidance that we were able then to reform, and the election atmosphere and what we enjoy today is largely attributable to the work that he did as chair of that commission. Justice Waki is now retired, having retired upon attainment of the age of 70 years, and he is currently serving in the board of directors at Nairobi Hospital, where he has been a member since 2020. In his private lifetime, Justice Waki enjoys playing a round of golf, and indeed today we are doing him a great disservice by keeping him away from his club nights at Karen Country Club. The next speaker is myself, and I am the deputy managing partner at the firm. I have around 14 years of practice, and I am largely a litigator or a practitioner of what is called dispute resolution. I have handled a number of local and international clients as well as cases, and also in succession matters, I have represented a number of clients. I also do employment and labor law, as well as banking and commercial practice. The next speaker we have is Claire Mwangi, who's a senior associate with us, having joined us in the year 2022 and has over 10 years of practice. She has also appeared in a number of cases comprising arbitration, constitutional and human rights law, judicial review, as well as capital markets and defamation. Madikizela Otieno is the youngest member of the team, and that being so, I confirm she has been the engine behind this team's work. She has dedicated quite a bit of her energy and resources coming up with this presentation, so we're very grateful to her, and she'll be joining us as a presenter in one of the key sectors of this presentation. She does hold a Bachelor of Laws degree from the University of Nottingham, as well as a postgraduate diploma from the Kenya School of Law. So, moving on to the key business for which we are before you today, we wish to share our thoughts and some insights on the law of succession in Kenya. And before I proceed, just a bit of housekeeping regarding any questions that you might have. Please do post them on the Q&A tab on your screen, and we shall take those questions at the end of the presentation. So, the Succession Act is an act which was made or came into force on 1st July 1981. The purpose behind the act's enactment was to consolidate or bring under one umbrella all the laws of succession in Kenya, which, because of our diverse makeup as a people, at the time was a bit divergent. We had a certain law relating to African people, a different law relating to Muslims and Hindus, and therefore the purpose behind the act was to consolidate the law and make it a bit more tidy, bring it under one roof, which was the Law of Succession Act. However, estate planning is not merely about what the act provides. It is the thought process that one has to go through in terms of realizing that we are all mortal beings, that one day we shall leave this earth and we shall leave people behind us. And the idea is to ensure that as that happens, it is as tidy as possible with regard to our estate, our assets, and specifically who does what go to. So succession planning is really about having that in mind and in the knowledge of what both the Act provides and perhaps any other options that you might have out there. Let's also now, before we delve deeper, describe or define some key terminologies that we shall be using so that it's not completely strange to you, starting with who is a beneficiary. So a beneficiary is essentially a person who's entitled to inherit property, either through a will or under the provisions of the Act. Another key term that you might hear quite frequently is a dependent, and a dependent is a wife, a husband, a child of a deceased person, or any other relative who can show that they're entitled to apply for provision out of the deceased person's estate. Estate on its part refers to the free property of a deceased person, and free property which I'll define a bit further down, whereas an executor or administrator essentially means a person who is authorized or tasked to execute, administer, or run the affairs of an estate. Full age means simply somebody who is over the age of 18 or otherwise known as an adult, whereas free property means property of a deceased person that person was legally competent or able to freely deal with during one's lifetime. And it means some property in respect of that proprietary interest which has not been terminated by virtue of one's death. And we shall examine as we go ahead instances where death terminates ownership within a property. Intermeddling is another key term which you need to take note of, and that refers to dealing with free property of a deceased person without sanction or authority of the law. And the reason why you need to know about this term intermeddling is because it is actually an offense, a criminal offense, and that it is prescribed under the Act and is warrants a fine of up to 10,000 shillings and even imprisonment of up to 1 year or to both. A grant is a legal document that gives an executor or an administrator the right, the power, or the authority to deal with the free property of a deceased, whereas a wife, a bit of controversial description, includes a woman who is separated from her husband, and the husband has a corresponding meaning. So according to this definition, it seems to encompass people who are separated from each other, having been previously married. A will, on the other hand, is a legal declaration or statement by a person of his or her wishes or intentions regarding how his or her property will be dealt with upon one's death, but it needs to be properly executed as well as attested. A will also includes a codicil, which is simply an addition to an existing will. Having gone through those key terms, let us now see what areas you might say amount to exemption, or where in what circumstances does the Act not apply. So number one is for Muslims abide by what is prescribed under Islamic law. So the Law of Succession Act does not apply to Muslims by and large, though there's an exception regarding administrators, where the law on succession relating to administrators in terms of their powers, functions, and duties, if not inconsistent with Islamic law, are still applicable. Estates that were predominantly pastoralist, and these have been set out quite expressly under the Act section 4, I believe, where it says that certain areas prescribed as West Pokot, Wajir, Turkana, Garissa, Marsabit, Isiolo, Kajiado, Mandera, and Narok, if you live there and your estate comprises of either agricultural land, crops, or livestock, those places are exempt from application of the Act. In those areas, what would be referred to is the customary law of the deceased. The key to note there is, I think, at the time when this Act was passed, which is 1981, these areas were without doubt predominantly pastoralist. But now I think areas such as Kajiado, there are some parts of Lamu, as well as Narok, it is arguable that they have since developed to not purely pastoralist communities. So perhaps there is a need to update the Act since it was enacted quite a while ago, almost 42 years ago. The estates of deceased persons domiciled outside Kenya are also exempted. So number one is where the estate comprises of movable property. And the deceased is then not domiciled in Kenya, but is domiciled outside Kenya. In that case, then the law would be the law of the place of domicile. And I think, Judge, we did have the occasion in the case of the state of Naphtali to consider this.
Yes, indeed, I did. But before I comment on the Naphtali case, let me say how happy I am to share this space with you today. It was worth sacrificing my golf event. I also want to issue 2 disclaimers. Firstly, that I'm not an expert in succession law. Otherwise, I would have written a book about it. And secondly, 4 years after retirement, you may expect me to be a little rusty and not to perhaps know what new areas of the law have developed or what new laws have been enacted. But having said that, I think I've interacted with this space, the succession law, for the last 45 years or so. 20 years as a practicing lawyer, 24 years as a judge of the High Court and the Court of Appeal. And I've also participated in administering some estates, particularly my late wife's estate, my late father's estate, and the estate of the best man in my wedding. So I have some good insights into the subject. And so coming now to the issue of domicile, you need to know that domicile has nothing to do with nationality or citizenship or residence. It really reflects on your civil status, the place you consider as your permanent place of residence. It could be original or otherwise. And so in this particular case, there was a man from Congo who died. Goma is in Congo. He died there during the war, the Rwandese and the Congolese war. And so his brother, who was resident in Kenya, tried to file a case in Mombasa, claiming a car, which he said had been left, for him by the deceased. And so the mother, their stepmother, came all the way to Mombasa to object to that application. And the issue that arose was whether indeed, in the first place, these people should be in Kenya applying for a grant of representation. And I had to consider whether the deceased was domiciled in Kenya, because there's a specific provision for that in our Act, Section 4. And that is why I did, following the law, hold that the deceased was domiciled in Congo. The car, the law governing that movable property, the only movable property ought to be the law in Congo. And that was enforced.
Excellent. Thank you for those insights, Jack. The other exception of application of this act is what is known as jointly owned property under the concept of a joint tenancy. By virtue of the doctrine of survivorship, such property falls outside the scope of the act. And what one needs to consider in this circumstance is whether indeed a joint tenancy exists at the time of the death of one of the two joint owners. On the death of a joint proprietor, his or her interest will automatically vest in the surviving joint proprietor, such that the remaining tenant automatically assumes full ownership of such property. It is an especially useful tool in terms of married couples who would reside within the matrimonial home under joint tenancy, and upon the demise of one spouse earlier than the other, then that would automatically vest in the surviving spouse. There is a case there of State Johnson Jogu, which I shall just say reemphasizes that concept, and it would reward careful read once one is able to follow that decision. The other exemption is through the concept called nomination, and nomination ordinarily occurs in the context of either fund schemes or cooperative societies, where the nominator nominates a nominee who would then be entitled to take up the share of funds that are owned by that nominator upon the death. So this, as I said, ordinarily occurs in the context of SACCOs, provident funds and pension schemes, and there's express ouster under the Cooperative Societies Act, as well as the Retirement Benefit Act of such funds. Again, there have been decisions which reaffirm these principles, including the state of Carolina Chen, as well as a case of Benson Mutuma Muvungi. Gifts inter vivos is another case where such gifts are taken out of the estate, and it's a Latin word essentially meaning a gift made during one's lifetime. The key thing to note in this circumstance is that for the gift to take full effect, there must be complete transfer to the beneficiary. It cannot be a partial or an incomplete attempt to gift away. And the cases of Godana Guyo, as well as Gideon and Zioka, reiterate this provision. Indeed, in the case of Mandin Zioka, the court found that the deceased had not completed the gifting away. In this case, it was a parcel of land, and it was found not to have been properly gifted away, and therefore formed part of the estate. So the key thing to note is that if you are to make a gift inter vivos, be sure to take the full steps of ensuring complete transfer. And that is what this slide emphasizes, that you must take proactive steps to follow the correct process and procedures, including making sure that the transfer does occur, registration happens, stamp duty is paid, and in cases of land, you actually give away physical possession of that piece of land. And the quotation from the Godana case merely emphasizes that the evidence must show that the deceased intended to make the gift of this particular property by taking steps to perfect delivery of it to the sons, to the exclusion of anyone else. Grants. We say that grants are the documents that give the person named in the grant the full authority and sanction of the law to deal with the free property of the deceased. And grants, by and large, fall into two categories: full grants and limited grants. Under full grants, we have either a grant of probate, which is what, if one is appointed as an executor under a will, you would obtain, whereas grants of letters of administration are obtained in the event a deceased person dies without a will. There are also limited grants which can be classified into the following. One is a grant ad litem, which is ordinarily taken out in order to step into the shoes of a deceased person in an existing suit. There's also the grant pendent litem, which is a grant taken out where there's a dispute as to the validity of the will, but pending that dispute, there's a need for somebody to step in and take charge and carry out the normal administrative process as the case about the actual validity of the will ensues. There's also the grant de bonis non intestate, where it is taken out where an administrator who has been charged with taking care of an estate actually dies before he has completed that process. So this is a way, you can call it a grant to substitute one administrator for the purpose of a deceased one and in order to complete an administered part of the estate. There's also the grant ad colligenda bona, taken out when there is an urgent or pressing need to carry out certain acts, but a full grant of representation has not yet been granted to anybody. A good case in point is where perhaps school fees needs to be paid for children of the deceased and no grant of representation has been made, or even where perhaps there's a harvest, a deceased person has a farm and there's a harvest to be made, and the only person who would be able to quickly step in is somebody holding a grant ad colligenda bona. So going ahead, the presentation will delve into three large sectors, being testate succession, followed by intestate succession, and those terms will be elaborated on. And lastly, we shall consider the issue of trusts. So over to you, Claire, to take us through the issues of testate succession.
Yes, so once someone passes on and leaves behind a will, then their property will be distributed as far as the laws of testate succession are concerned. So basically, testate succession refers to a scenario where one person dies and there's a valid will that is left behind. It is important to emphasize that the will has to be valid. And so in doing this, then we need to ensure that when a will is being drafted, the key elements have been met. The first one being capacity. Capacity is in the aspect of, it's twofold. So children cannot make wills. Wills can only be made by people who are over 18 years. So that's the first aspect of capacity. And the second one is that they have to be of sound mind. We do call Banks as good fellow, where the court examined what mental capacity entails. And the first is that you have to be able to remember or to know that you're making a will, remember all your property, and remember the people you're gifting your property to. Now, when these three aspects are not met, then a will will be said to not have been made with the mental capacity of the testator, and therefore it will be declared valid, and therefore everything you would have said in that legal document indicating how your property should pass will not be taken into effect, given the invalidation of that will. We have a case. In this case, the estate of JFF, what happened here is that after the deceased passed on, the children went to court challenging the will of their late father, saying that their father lacked the mental capacity to make this will. It should be declared void. He had psychiatric illness. He used to take psychiatric medication. And so because of that, he definitely did not have the mental capacity, and his will should be declared valid. So the court examined these scenarios that the children were giving, including the fact that at every meeting that the deceased father attended, he had to take notes to remember. And so according to the children, it showed that he could not remember anything but for the fact that he had notes. The court was of the view that if the reason why he was taking notes like this was because he was a very organized man who needed to have these notes serving as reminders to him. But what was important was when these children said that the father did not have mental capacity, the burden shifted to them to prove. And the court observed that no medical doctor was presented to confirm that writing of notes compulsively at every meeting was attributed to his mental incapacity, or the fact that the medication he was taking as a result of his illness impaired his judgment to such an extent that he could not write a will. Without this threshold then being met, then the court found that the will was valid. So what we are learning from this case is that it is not enough to say that a deceased person was old, he was sickly. No, it's a really high threshold when you invoke mental incapacity. Now, this capacity should be there both in written wills and in oral wills. As far as oral wills are concerned, the criteria for capacity is one of them. The other criteria is that there has to be two competent witnesses present when you're making your oral will, and that for that will to be valid, the testator must die within 3 months. Now, the rationale given for the requirement that the testator must die within 3 months is because the court has found that when wills say you write, you dictate, you say your oral will today, and then you die 10 years later. 10 years later, we now have to call your witnesses to tell us what did the testator say. I mean, that period of time is enough for people to forget, your witnesses to forget, or to even misrepresent. And so the 3-month limitation is so that you can convert your oral will into a written will. The other rationale behind the 3-month limitation is because it is presumed that by the time you're making an oral will, there are circumstances that are forcing you to write to state that oral will, maybe because of fear of death, anxiety, possibly in a hospital, and so death at that point in time is imminent, and therefore it is possible that what you're saying at that point in time would not have been said if at all those circumstances were not present. And so that 3-month period gives a testator an opportunity to convert their oral will into a written will. Otherwise, if a period of more than 3 months passes, then that oral will not be valid. And we do have instances where the court has upheld oral wills. One of them is the case of Rufus Ngebe, where this is a case where the deceased called 2 witnesses and told them how they wanted and the property distributed to his wives and children, and he died. And these people went and recorded that will in writing, and the deceased passed on later. And the court found that that was not a will. It's important to note that recording a will in writing does not make it a written will. So that was the case of Rufus Ngebe. The other one is the Court of Appeal case of Wamboi and another. Similar to the Rufus Ngebe case, the deceased, who was very illiterate and called some witnesses to his compound, dictated his will in Kikuyu. Those persons went and typed that the wishes and read back to the deceased being illiterate, his thumb printed, and that was construed to have been an oral will. Now, back to written wills, execution is important. So for oral wills, you don't need to execute anything. So what we are saying is that the execution in those two cases, or the writing, the typing, the thumb printing, was not really a critical factor. For oral wills, we need capacity, the 3-month threshold, and 2 competent witnesses being present. For written wills, you have to sign the will. That's execution, and next you have to attest. It has to be attested. Attestation means 2 competent witnesses must sign against your signature. So yes, you have signed, and then they're also signing against your signature. I know Justice Waki has had an opportunity to deal with a Court of Appeal case, the case of Ngegi Muigai and another, and maybe he can share his insights.
Thank you, Claire. Yes, indeed. It is a reported case. We decided that case some years ago. And it's in our opening statement, we said this is yet another high-profile estate of a deceased Kenyan, which has defied closure on account of incessant squabbles between the beneficiaries. We said that because we had dealt with very many cases of prominent Kenyans. There was a Koinange case, there was a Kirima case, there are others, which always go all the way to the Supreme Court, if not the Court of Appeal. And a lot of waste is incurred and delays are incurred. And so in this particular case, the issue was really about complying with those requirements of capacity, execution, and attestation of a will. And we did emphasize, we did go through those requirements. And on attestation, the contention was that the witnesses who witnessed the will of the deceased were not present at the same time when the deceased was making the will. One witness came earlier, witnessed the signature, then the other one came much later and did the same. And when we examined the process that they went through, on the evidence, we upheld the will on the ground that it did not matter that the 2 of them were not present at the same time when the will was signed. There were other arguments about capacity, the state of mind of the deceased, etc. And it makes interesting reading when you go through it. Thank you.
Yeah, so thank you, Judge. Apart from, now, when you then write a will, the intention is that the entirety of your will, you want it determined by way of tested succession. So what happens to those properties that you acquire after you have written a will? Or say in your will you had bequeathed, say, your father, your mother, then they die before you. So there is that aspect again of that bequest that does not have a beneficiary. Or say you were a joint owner, as John indicated at the very beginning, joint properties do not form part of the free property of a deceased. And the reason is, when one joint owner dies, it automatically vests to the other person. So you see, at the time it's joint, it does not form part of either. It's jointly owned. But later, say your joint owner passes on. So it means it's now yours, and it was not provided for in your will. And that is where we have a residuary estate clause in a will. What this clause does, it provides for the remainder, everything else that you have not stayed in your will. Because remember, our will is very specific. It says your house in Muthaiga goes to this person, your property at the CBD goes to this person, your car, KA Watt, goes to this person. And so what happens to everything else? So then that residuary estate clause comes to cover anything else that may not have been contemplated, may have been forgotten, and it provides for how that property should pass. There are advantages of making a will. And then again, we do appreciate not a majority of Kenyans write will, because even from our end, whenever we do a search we do have a search engine that is usually maintained by the judiciary called Kenya Law. It's a Kenya Law website. Whenever you search for succession cases, the majority of all the cases that come up, a majority of them are in respect of estates where wills were not left. So we do appreciate we are a country where we are not in the habit of making wills, and maybe it's because of various reasons. Possibly it's taboo for some people to talk about their death. Possibly it's cultural reasons. Possibly it's the fear of death for some of us. But there are advantages. We do reckon that there are advantages of making wills. One of them being that you're able to maintain control over your property. As we have indicated in a will, you specifically state your property, specifically state to whom it is going to, specifically state the portion. So there's no ambiguity. You're in control of everything as far as your distribution is concerned. And by so doing, you even avoid intestacy proceedings. Another important aspect is appointing personal representatives of your choice. Now, when a will is written, a will is simply a legal declaration of how you want your property to pass. There is the person who is responsible for seeing your property change hands once you die. That person is called an executor. You choose that person as well. So you're able to choose someone that you trust to undertake this very important aspect of the distribution of your estate. Another advantage is administrative convenience. And this is quite contrasted for when someone dies without leaving a valid will. Because where there is a will and the deceased passes on today, the executor begins work immediately. They do not need to go to court for any letters. They do not need to apply to court for, and this is what happens in intestate succession. If you die without leaving a will, your personal representative cannot do anything without a grant. And that is the permission of the court to deal with your estate. Because if they do, then they are liable for an offense called intermeddling. But as far as wills are concerned, whenever the executor finally gets a grant, it will basically be confirming this authority that was given in the will. So that's the really another advantage you see in writing of wills. There is also full disclosure of your assets and liabilities. You're able to put everything in one document, as contrasted to if you die without leaving a will, the people you leave behind begin a fact-finding mission. They are now going to think, oh, account here, or they had property here, and then start trying to establish that property with proof. Because remember, when property is being distributed by a court, it needs to confirm that indeed this is the title held in the name of the deceased. This is a cert, indeed it is held in the name of the deceased, and this is how it's passing. This documentation can be a problem in intestate succession. And we see the testate succession makes it much easier for your next of kin to enforce your instructions. The other one is you then avoid disputes over your estate, and you're even able to benefit people outside your immediate family, because you see, for a will, you can provide for anybody. You can provide for your father, for your mother, for your domestic worker, for your security guard, for charitable institutions, but not to intestate. Intestate is a one-size-fits-all. We're dealing with dependents. We're dealing with children and wives. So even if you had a friend who you held near and dear, they are not within the contemplation of intestate succession. You're also able to, it's also easy to make wills, as we have pointed out. The three elements need to be met. The other is control over your funeral and final resting place. We have seen that in the past, we have read in the media that Bob Collymore, for example, and Charles Njonjo were cremated, and we have read in the media that it's because they indicated that that's what they wanted as far as their wills were concerned, and therefore you're able to control this. But we do need to point out that there is no property. The court has held, especially in the case of Pauline Dete Kinyota, that there is no property in the body of a deceased person. Therefore, it means if you say you want to be cremated, that is a request. Your executor does not need to abide by this. It's merely, for as long as it's practical, they will do it. For as long as it doesn't contradict customs, they will do it. But they're not mandated to follow your instructions. And so therefore, if you then say that, say you want to be cremated and then you want your property, your ashes to be transported to the Bermuda Triangle and scattered at midnight and recorded on Twitter and IG, if they feel it's impractical, if the executors feel it does not follow customs, they will not abide by it, and there is no law forcing them to do that. And just in the same way that a will is written, it can easily be revoked. And then there are a few disadvantages of making wills. You will note that the advantages of making wills outweigh the disadvantages of making wills. So the thing is, in as much as you have the freedom to dispose your property, it has to be within the confines of the law. So you will not leave out your people, the people who depended on you, like your children. There is a case of Popat versus Popat. The Court of Appeal addressed itself and provided for a son who had been left out in a will because had been left out in a will because the father had not given any reason, but the court found that a child cannot be left destitute. He will be provided for. He should be provided for, and the court then interfered with the testamentary freedom of the deceased to that extent. We also have the case of Elizabeth Kamen Ndono versus George Matata Ndono, where in this case the deceased had 3 wives, but had loved the 3rd wife more, called Elizabeth Ndono, and left everything to the 3rd wife. The first 2 wives were just so unhappy, and they went to court to challenge the fact that their late husband provided nothing to them. And what the Court of Appeal provided for, it recognized the power of a testator to dispose of his property as he so wishes, but he cannot hurt those people that depended on him. And because of this, the court then interfered with the will and apportioned this property and provided for provision for these 2 wives who had been left out. So Elizabeth, the favorite one, got a majority, 40%, but then the others got 30%, 30%. And so that is the extent of within which a court a testator should make his will, considering everybody who depended on him and not just abusing that power because the court may interfere with it. And so we will then go to the next aspect of intestacy, which will be addressed by John.
Thank you, Claire, for that excellent presentation. Intestacy is actually what governs the majority of Kenyans. And for reasons alluded to by Claire, it is perhaps because death is a taboo subject in the context of African culture, and we tend to shy away from discussing it or even contemplating it. Perhaps it's a view that if you go see a lawyer, the lawyer might charge you a lot of fees to draft a will. But for whatever reason, intestacy is the majority manner through which estates of Kenyans are administered. So intestacy means that you have not, upon your death, left behind a valid will, or if you have left behind a will, tried to leave behind a will, it has subsequently been invalidated by court, or perhaps you had an existing will, you then revoked it, and then subsequently write up a new will. And the law on intestacy provides for devolution of the deceased person's estate based on the acts on prioritization of dependents, depending on possible scenarios of who exactly you have left behind upon your death. And we shall examine those scenarios as follows. So number 1 is where you leave behind one spouse and you also leave behind children. What would happen in such a circumstance? So the law is that in that case, the surviving spouse will take up the personal and household effects of the spouse. So this relates to furniture, personal items, clothing, jewelry. That will all go to the surviving spouse. But in addition to that, the net estate, you will then acquire what is called a life interest in the net estate of the deceased. Now, the law subsisting before a certain case, known as the Ripples case, was that in the event the surviving spouse was a woman, therefore a widow, if the widow would go ahead and remarry, then that life interest terminates. The court in the Ripples case, upon consideration of the current constitutional dispensation, which is very pronounced in terms of non-discrimination, has actually found that this does not meet constitutional muster, and has directed that this provision that says that if it's a wife that or widow rather that is left behind, that life interest terminates is unconstitutional because there was no similar provision in the event of a husband surviving a wife. The other scenario is where a deceased has left behind a spouse but not children. In this case, the surviving spouse is entitled again to the personal and household effects immediately, and then to the first 10,000 shillings. Princely figure of 10,000 shillings can hardly get you to Kisumu on fuel nowadays. And the net estate up to 20% there. And so I think, as I said, this act was made in the year 1981 and 10,000 shillings was a lot of money, but nowadays certainly not. In this instance, the advice would obviously be to resort to the 20% as opposed to the 10,000, as the law is perhaps looked at and brought up to speed with current realities. The other scenario is where the deceased has left behind a surviving child, but no spouse. In that case, the entirety of the net estate goes to the surviving child, obviously subject to them having reached the age of majority. Otherwise, before that, then our continuing trust comes into play. Now, where the deceased has left no spouse and no children, in this case, there is a very clear order of priority that is set out under the Act. Number one, fathers are listed as the inheritors. And if the fathers are dead, then the mother. And if the mother and father are dead, then you go to the brothers, and then a child of such brother and sister, and then the half brothers, half sisters, and their children. And then you look for cousins to the 6th degree, up to the 6th degree of consanguinity. And failing that, then it is actually forfeited to the estate under the principle of vacantia. Now, the case of Ripples, which we cited earlier, has also said that the provision relating to parents, where a father is put in priority to a mother in inheriting the estate of the child who is deceased, has also found to be unconstitutional. For obvious reasons, they should be at par. And what is good for the goose should therefore be good for the gander. And the Ripples case similarly struck that down as unconstitutional. The other thing you would need to bear in mind is what is the definition of a dependent. So Section 29 of the Act sets out who dependents are in two categories. Number one is where you don't have to prove maintenance. Now, under this category are listed the wife or wives or former wives and children of the deceased. Obviously, there's an issue where the husband is. Then, if, and you say it now, if you need to show that you are maintained by the deceased, you would then qualify if you're a parent, a step parent, grandparent, grandchildren, stepchildren, or children taken in by the deceased, as well as brothers, sisters, half brothers, and half sisters. And then it says where the deceased was a woman, and therefore you are the husband, you need to show maintenance. I wonder where the court in the Ripples case was in this regard. This should similarly have been struck down if it was up to me. Another key definition or key concept one needs to look at is who exactly is a wife under the context of succession. And the reason why this is key is that if you consider the definition of a wife under various other provisions of the law, most notably the Marriage Act, you find a completely different meaning as that prevailing within the Succession Act. But for purposes of the Succession Act, a wife is construed to include, obviously a wife, first of all, if you have a certificate of marriage and you're listed there as a wife, then you're the wife. That one does not dispute. But the Act also recognizes what is called a common law wife. So you're a wife by virtue of repute. People, when asked, they just know that is a wife and so because they're always together, they cohabit together, but in real fact, they're not married legally. There's no instrument of marriage that can be demonstrated. That is called a common law wife. But there are also wives who are married under custom. So you performed a customary ceremony, and in various customs and cultures, there are different ceremonies. So if that has been performed and you have taken maybe more than one wife under that particular custom, for purposes of succession law, those wives are considered as wives, which is contradistinct to the Marriage Act, which actually ousts such marriages as invalid. And therefore there's a clear conflict. But the answer to this conflict is that if you're dealing with succession, then it is the Law of Succession Act that you will be guided by and not any other act. But if you're dealing with divorce and distribution of property within divorce, then the Marriage Act will come into play. That has been elaborated upon in various cases. And in the case of Wanjiku Yahweh, that went into considering what does one have to show in order to qualify as a common law wife. So the court will consider things such as, were there any children fathered by the deceased? Was there property that the couple or the married couple, for that matter, went ahead and acquired together? And they'll also look at whether or not some form of ceremony was performed. So all these factors, there's none that is the clincher. It is not merely fatherhood alone that would demonstrate, but the court would consider a variety of factors as set out in this case to determine whether or not the cohabitation was of the quality required to presume a marriage subsistence. The other key consideration that we would want you to bear in mind is what is called reasonable provision. As Claire mentioned that during her presentation, it is not permissible for a testator, somebody making a will, to bequeath property and leave out a dependent of his, because the court will then allow that person to come in under Section 27 with an application for provision. And when the court is satisfied that there is such a dependent, but obviously it has to go through the process of judicial application, assessing the facts and applying the law in order to qualify as a dependent. But the moment you qualify as such, the court will then look at certain things. First of all, what is the amount or the extent of this estate? What are previous gifts or contributions that the deceased has given to you prior to the death of the deceased? Also, what are the reasons? The deceased might well have had a very good reason to leave you out of the will, and that will then come in terms of balancing it. The court will perhaps mitigate, not to leave him out entirely, or him or her out entirely, but look at if there are reasons, then how does it balance the need to provide, but respect such reasons. So there's a case of John Gitata Mwangi, and in this case, there was a rather curious relationship between the deceased and his son. They were on such bad terms that the son had actually left the country, and prior to the deceased death had actually completely lost touch with the deceased father in that case. And even when the father died, the son did not attend the funeral. That's of course a huge statement. And in that case, the son, nevertheless, was able to apply for provision, and the court then balanced the interests of a testator or deceased person saying, I don't want so and so to inherit, and for certain reasons. The other thing that would be key is what is this issue called life interest? Remember when we said that a deceased person leaves behind a surviving spouse, he or she is entitled to a life interest and then a balance of the net estate up to 20%. So a life interest essentially allows you to continue enjoyment of use of the property of the deceased, but does not allow you to transfer it or deal with it in a way that eliminates it. But if there's a need for you to indeed transfer such property, you are still, as a person holding a life interest, able to do so by either obtaining the consent of all beneficiaries or approaching court with an application for consent to deal with what you hold as a life interest. And as we said, in the Ripples case, the court has since said that that life interest issue terminating upon remarriage is unconstitutional because it only said that it applies to women. A continuing trust also is a key thing to note because it is what is brought into operation if the beneficiary of an estate is a child who is not yet 18 years of age. So in that case, the administrator is immediately converted into a trustee and holds the property in trust until the minor becomes of age. Polygamy and intestacy. As we said, the Act is quite express in its recognition of polygamous marriages because of the plurality. They use it says wife and wives, or wife and former wives. So the use of plural in itself shows that the Act admits for polygamy, but also Section 4 is quite clear that polygamy is recognized. So in the case of intestacy in a polygamous marriage, what happens? Because there are many wives, there are many children, there are many houses, and houses in the context of succession law does not mean a physical house. It means a wife and her children. It means a social house, not a physical. And Judge, I think you are involved in a key case of one of your own when an issue of intestacy in a polygamous setup.
Yes, Rono versus Rono was a case that broke some new ground addressing the existing environment at the time relating to discrimination against the female of the species. Of course, this was before the new constitution in 2010, and that is why it was new ground. The main issue was whether some female children of the deceased were entitled to inherit, and if so, in what percentages. And I think we went through the provisions of the section itself. And since it was not clear how we were going to deal with it, and the High Court had done the distribution in a manner that discriminated against the female children, we went to international law to borrow some principles there, and we found that they were applicable and they influenced our decision. And therefore, in the end, we distributed the estate equitably. On the facts of that case, it turned out to be equal shares for the boys and for the girls. But the principle is that the estates, depending on the circumstances, would be distributed equitably without considering, merely considering the sexes or the gender of the children.
Excellent. And I know, Judge, in that case that the bench was more or less unanimous with your lead judgment.
It was unanimous, although there is the statement by Justice Omolo, which Kubasu J agreed with, that explaining that the understanding of the decision is not that there will always be equal distribution of this property between the two, the male and the female children of the deceased or the houses. They emphasize that the judgment focused on equitability of the distribution, and that's what it was.
And it is a decision that today stands as good law, notwithstanding the entire shift of the constitutional dispensation. So it was a decision that was actually ahead of its time, as it were. So the other issue we would want to run through quickly, as we see that time is not on our side, is what really is the process of administering a decision. How does one really go about it in practical terms? So number one, you must apply. You must actually go to court, which is not something you can do without court authority, and apply for what is called the grant of letters of administration. And that process is set out under the Act, is quite detailed. But briefly speaking, you need to make a petition, present that petition to the court, and it is gazetted in the Kenya Gazette for a period of 30 days, allowing for any objections to be made within that period of time to the proposed administrator. Now, assuming there's no objection, then a grant should then issue at that stage. And thereafter, 6 months later, you can then apply for what's called confirmation of grant. Before the confirmation of grant, if anybody wants to challenge, you may do so. But if a grant is confirmed, then the only way you can challenge is through applying for its revocation. The entirety of time it takes is approximately, because of the working conditions of our court, they are quite busy. I would approximate it at around 1 year for you to obtain the grant, and then within the 6 months apply for the grant. But in some busy stations such as Nairobi, it actually takes a longer period of time. But in the outstations where perhaps there are less people moving court, you might do it within a shorter period of time. Now, once a grant has been confirmed, it is the function of the administrator to go ahead and actually distribute the estate to the beneficiaries in accordance with the schedule which the court will have looked at and will have approved. But obviously that distribution should come after payment of all debts that are accrued against the estate, including perhaps any taxes, debts owed to creditors, and so on, so that the beneficiaries only inherit the net, and that is why it is called the net estate. So Section 66 sets out a priority of persons who may apply for grants, and that is the surviving spouses, and then other beneficiaries, the same ones who we listed earlier, starting with parents, and then go to the brothers, sisters, so on and so forth. The public trustee, in the event anybody who is not interested in an estate, can also move court by way of an application, and there is in fact a case where the public trustee did so. Creditors are also entitled to move, but then they are the last in the queue. And any one of the succeeding people are allowed to revoke their entitlement or to consent to somebody of a lesser rank applying for the letters of administration. There's a key decision I quickly want to go through, which is the case of Kituku versus Ndaka. An interesting case and sad at the same time, because it concerns rather a family that perished in a fire in Malindi. In a school in Malindi, there was a fire that gutted down the house, but the entire family was sleeping when this fire happened, and therefore there was a complete wipeout of the family, man, woman, and the children. So in this case, there was a dispute, a serious dispute between the two families. That is the family of the man and the family of the wife, as to who should take out letters of administration. So the family of the husband had moved to court saying that under Kamba customary law, once dowry has been paid, that wife is assimilated, she is subsumed to her wife's family. It is as if the other family has completely relinquished any right to her. And that is a custom of the Kamba. I do believe, being a member of them, not a very keen professor of them, but I do believe that I have heard that say. Now, the court grappled with two issues there. Number one, who survived the other? Remember, there was a fire. So both people were, they died, and it's not clear who died first. And so that doctrine that I talked about earlier comes into play, the doctrine of survivorship. So the court applied its mind to it and found that under the law, if it's a man and a wife who die under circumstances that it is not clear who predeceased the other for the purposes of survivorship, they are deemed to have died at the same time. So that is the first thing that helped the situation, as it were. But the other thing or issue that came into play was where does the customary law of the Kamba people become applied? And in this case, rather curiously, the judge arrived at the decision, but through a roundabout route, because what the court found was that the level of proof required was not sufficient, because they had referred to Kamba customary law, but he said, look, no, it's not good enough. There's no text that has been advanced. There's no elder that you brought to really say that this is what the Kamba people believe in. And he therefore found that the quality of proof of Kamba custom had not been met. But I say it is rather curious, because remember that in the beginning, we said that there are various areas that are exempt from application of the act, and that customary law is then called in. And Malindi, which is where the people were domiciled or lived at the time of their death, is not one of the 50 places that is excluded. And therefore, the judge should simply have said there is no occasion to call in Kamba customary law, because the Law of Succession Act is explicit as to when customary law applies, and Malindi is not one of the areas. But in any event, it was still a correct decision, saved through a different route. Now, there are some advantages of intestacy, believe it or not. Number one is that cultural norms are actually allowed to prevail. And for those who hold the custom dear to themselves, then intestacy will actually have some regard to custom. And there are some judges of the older days who are quite keen on upholding customary law. Such will then come to their aid. It also caters for those people who are opposed to this business of contemplating death very clearly and writing it down, putting pen to paper as to matters of death. So those who still hold that contemplation of death is taboo to them, then there are elaborate rules that now kick in when intestacy comes into play. There's the notion that, look, because intestacy really looks at relation by way of blood. It is, you need to show you are related. And you can go all the way to a sixth cousin in order to inherit. So the notion that blood is thicker than water is actually upheld under intestacy provisions. But of course, this can be both a good thing and a bad thing, and we look at the flip side of that. The major disadvantage of intestacy is the length it takes just to intestacy matter in Kenya. Most notably is the case of the state of Mbuko, where Muchelule, Judge Muchelule, as he then was nice Court of Appeal judge, stated, and it's a very poignant quote, where he says what a man Mbuko was followed. That what is not appreciated is that most of the cases involving rich polygamous Kenyans who die intestate have followed a similar pattern: lengthy and complicated litigation, attracting many advocates and less intention on the part of the parties to bring the matter to an end. You know, he's saying really the only people who benefit in this business of lengthy litigation is the lawyers. One wishes that all Kenyans can get into the habit of planning their lives, and especially thinking about what will happen to their families and properties upon their death. It is not too much to ask that the planning be by way of writing. So Muchelule was really advocating for writing a will to reduce the possibility of conflict. That, of course, as Claire noted, that one of the potential litigations in an issue of a will is whether the will itself is valid. So still, yeah, you can write a will, but it might still. But it's just that the extent of contestation is limited to whether or not the will is valid. Disadvantages of intestacy is that it is quite different. I mean, the moment somebody dies intestate, it immediately becomes a game of you're on a fact-finding mission. What did the deceased leave behind? What are the assets? What are the liabilities? So I equate it almost to a game of hide and seek, where the deceased leaves the assets, and then the administrators and the beneficiaries are left to seek. And it's many a times you stumble upon these documents of ownership. And so we wonder really how much property out there belongs to deceased people who died intestate and nobody knows about it. It also entails a lack of control, because you have absolutely no say. Once you die, what we look at is the law of succession on intestacy and apply those laws. And it's a one-size-fits-all. So if you liked somebody better than the other, or if somebody had annoyed you, and they'll still get their full entitlement under intestacy. So if you have a case where you want to leave some clear direction as to who should get what, then intestacy is not for you. There's a very good example of really how murky the waters can get, or how chaotic it can get. And I would leave it to, at this stage, play a short video demonstrating really what had happened in this case of Christopher Mbot.
A Solomonic order by consensus by Thika Law Court's Chief Magistrate Stella Atambo has saved the two families of a deadless court battles. Two widows of Christopher Mbote were fighting over the location to bury their deceased husband until the matter came before the Chief Magistrate, who took her time to have them agree on common ground. And as NTV's Claire Mwangi now reports, the billionaire will be buried in the fence that separates the two homestays.
These two women are united and divided by the same force. A dead billionaire who they both wanted buried in their preferred spots. The two are the widows of Christopher Mbote, who died in January 16th this year. The body of the deceased was to be buried on Friday, January 27th, but the second wife, Anne Jerry, went to court claiming to have been excluded from the funeral arrangements.
It will take 2 hours. How many hours?
When the matter came before Thika Law Court's Chief Magistrate Stella Atambo, she was quick to discern the motive of the suit.
If you would sort out this matter amicably, itanyamazisha kila kitu. Hata watoto watatulia. When you come to succession, which I know is the issue ahead, is just that it's not being talked about, then we will all be reading from the same script.
Atambo spent several hours pleading with the two families to avoid a court battle and give the deceased a befitting burial.
Tafadhali, maneno ya wafu ni maneno ya heshima, na ni ile maneno tunashughulikia tukinyenyekea.
The chief magistrate then ordered everyone to leave the courtroom, apart from the 13 children of the deceased and his two wives.
Because no matter how emotive...
It was at this juncture the two families decided to bury the hatchet and agreed that the deceased should be buried between their houses. After Atambo's Solomonic order by consensus, it was agreed that Mbote's grave will be dug on the fence separating the two houses, with a government surveyor being involved.
And the only way to stop it, mzee mwenye boma, mzee mwenye mali yote, and all these people in court, awekwe mahali decent, where all his children can access him, all his wives can access him, all his relatives can walk in and visit the grave without drama.
Further, it was agreed that the second wife should be involved in the burial arrangements, which has now been pushed to February 3rd, that will be carried out under tight security. Martin Mwangi, NTV.
Yeah, so that clip really demonstrates exactly how dicey the situation can get, whereby the eventual settlement was to bury a deceased person right in the fence of two houses. So the other, I want to go quickly now because we are running a bit out of time. The other disadvantages are that intestate, and this can be looked at both as an advantage and a disadvantage. It is based, as I said, entirely on kinship. So non-blood relatives such as in-laws and perhaps parents-in-law simply cannot come into play under the rules of intestacy. And there's a case there of Gashara Gikono that states or emphasizes that point. The duties of a personal representative. This is key to note, because if you find yourself as a personal representative and you breach any of these duties, then it is a sanctionable offense under law. So number one, pay the funeral expenses and give the deceased a fitting send-off. Of course, I think one of the key questions is, look, by the time the deceased is to be buried, it's typically 2-3 weeks after the death. By that time, hardly anybody has been appointed as a personal representative. So perhaps more theoretical. But the one that comes into play, no doubt, is you need to apply for the grant of representation and pay the expenses attendant that. Judge, there's a case that we told them, and perhaps you shed light, elaborate on one of the duties, which is to get in and collect all through the free.
Yeah, I'll just refer to the Anjarala case, which I decided when I was in Mombasa those many years ago. And this was to emphasize that once a grant of representation is made, there are duties that have to be carried out expeditiously. And unless there's a reason for any delay, the completion of the administration of the estate must comply with the law. And so in the Anjawala case, the wife, in fact, there was a will and she was given a grant of probate of the will. And for about 10 years, she was just involved in some squabbles here and there, but not really explaining to the court or to the beneficiaries why the delay was. And so when the matter was brought before me, it was for other reasons, which I found not to apply, but on my own motion, I referred to the law, and I observed that there was a delay by the executor, and therefore I issued orders that must be complied within a period of 90 days so that the estate can be administered in accordance with the law.
Thank you for that one, Judge. So amongst the other duties that of a personal representative include to ascertain the debts. Remember, it's not all about the assets. Many a time people leave behind a mountain of debt. And in fact, debts rank in priority of assets. So you need to go ahead and actually establish debts, have them paid off before giving the balance to the beneficiaries. You should also complete an inventory of all assets and liabilities once you establish them, and that should be done no more than 6 months from your appointment. So obviously, you need to distribute all property once you've paid out the debt. This is what is meant by actual inheritance. And you should complete, ideally, this process within 6 months of confirmation of that. And after completion, you go to court and give an account to the court of what exactly you have done, and you render what is called a full and accurate account of the completed and special to then be discharged. Failure to abide this solemn duty attracts penal sanction, which you should be aware of, including imprisonment of up to 1 year, together with a fine of 10,000 shillings or to both. I think the only thing that is excluded is strokes of the cane. Next one, section 79 actually just reiterates that by virtue of your being named as a personal representative, you then have the power and the authority to deal fully. You essentially step into the shoes of the deceased person, and the property should rest in you for purposes of eventually transferring it to the beneficiary. And remember at all times that yes, you might be the administrator of property vests in you, but you're holding it as a trustee. You're in a fiduciary capacity. It is not for your own benefit, although many times you might be both administrator and beneficiary. But for as long as you're administrator, it is for the benefit of the ultimate beneficiaries. Under section 82, you have the power to enforce causes of action that are accrued and survive the deceased. And you're also entitled to sell part of the estates that vest in you and then vest the property in the beneficiaries accordingly as per the confirmation of grant. The next sector of the presentation, and which is the last, relates to a very interesting area called trust, and it is becoming increasingly prominent. And for that purpose, Madikizela will take us through the same.
Thank you, John. So having considered intestate and testate succession and identifying a tool for succession planning, which was wills, the other tool that we will consider today is trust. So a trust is a legal instrument that is created by a settlor. And in this circumstance, the settlor transfers legal title to their assets to a trustee who holds these assets in trust for the benefit of the settlor's beneficiaries. So in this instance, the trustees are essentially the managers of the trust. They do not derive any benefit, they do not take in any income, they only manage these assets and then thereafter transfer income to the beneficiaries. So this tool would be useful to someone who has maybe a family business or some kind of asset that needs to be run professionally, and you might fear that your beneficiaries, although they are entitled to the income from these assets, might not be well suited to running them. You may want to vest your property in a trust, and in that way, the professional runs it on behalf of your beneficiaries. There are various types of trusts, and trusts are mainly distinguished either by their formation or by their operation. So trusts which are formed whilst the settlor is alive are known as living trusts, whereas a trust that is formed upon the death of the settlor is known as a testamentary trust. In terms of operation, you can have either a discretionary trust or a non-discretionary trust. So a discretionary trust is one where the trustees are given broad powers of managing. This means they would be able to invest, buy, sell, and even transfer assets. And when it comes to paying out incomes to beneficiaries, they are also given the discretion to decide how much income on a need-to-be basis. So this trust might be useful where you have a lot of trust in your beneficiary, in your trustee, and it's someone who you think knows what is best for your family. A non-discretionary trust, on the other hand, is quite strict. In this sense, the set law puts everything in the trust deed of how the trustee is to distribute income to which beneficiaries, and possibly even on a fixed schedule. So the trustee in this instance doesn't have a lot of wiggle room. They must follow the trust deed. And in this way, you get to, for someone who is seeking a lot of control over your assets afterwards and how much income goes to beneficiaries, you would be able to create a non-discretionary trust. So as I said earlier, trusts which are created upon the death of the set law are known as testamentary trusts. So these are trusts that are usually created as part of a will. And so as you're drafting your will, you may decide that there are some assets that you want to bequeath in the will directly to your beneficiaries, and there might be assets that you want to put into a trust. So these assets that are in the trust would then be managed by a trustee on behalf of your beneficiaries. Some advantages of creating a testamentary trust are that you would be able to provide for beneficiaries who are minors, or even those who may lack the mental capacity to be able to manage the assets on their own. So as I mentioned before, the trustee, who is more or less the manager, would be able to run these assets to the best of their ability, and any income derived from that would then be shared out to your beneficiaries. Another advantage is that, like in the instance where you have a business which requires professional services or a certain skill set, you can appoint these professionals to be the trustees of the asset. And so where the income and profits are coming in, those trustees don't have access to it. They would just then transfer it to your beneficiaries. You would also be able to put in conditions, preconditions to your beneficiaries receiving assets. Let's say you would wish for your beneficiaries to have attained a certain age, or let's say once they are married or once they have children, they are then entitled to accessing certain properties and certain assets. So this is something that you can employ in a testamentary trust. It is also multi-generational, which means that you can provide past your immediate next generation. You can provide for your grandchildren and possibly even your great-grandchildren. But it's also important to note that there is a rule against perpetuities. So you wouldn't be able to provide indefinitely, but you would avoid the instance of your estate wasting away within one generation. Another salient fact that really lends itself to trust is the fact that your properties avoid divorce proceedings. So assets which are vested in trusts aren't usually subject to divorce proceedings because they are not matrimonial property. If one of your beneficiaries is ever in an instance where they are getting a divorce, any property which they enjoy is already in the trust, which isn't really their property, it's trust property, and therefore cannot be used for purposes of any division in divorce proceedings. Despite these advantages, there are a few drawbacks to creating a testamentary trust. As I had mentioned, the trust is created under a will. So in the event that, as we had discussed, the will has not been properly executed, if the will is invalidated, the trust that is formed under this will would be equally invalid. So it's not entirely foolproof, because you would have to, the will would have to go through the probate process, which requires that the will is declared valid, that the executors take out the probate, and then thereafter the trust can come into operation. So obviously there's a time issue here as well. because you would have to go through the probate process, which, as John mentioned, can take anywhere up to 1 year. As mentioned by Claire earlier, there is the very famous case of Charles Njonjo, who is Kenya's first Attorney General and passed away last year. He passed away testate, having a will, which he drew. It's reported that the will was drawn in 2020. And some 3 unique features of this will is that, 1, it provided for his final burial rites. He indicated that he wished to be cremated and that his ashes should be scattered in his estate in Kiambu, his 2 estates in Kiambu. And he also created a discretionary testamentary trust where he allowed for trustees to run assets on behalf of his beneficiaries, which were his 3 children, his surviving wife, and his grandchildren. So also important to note in this feature, in this will, is that he provided that any spouses to his beneficiaries, so the wives of his sons, this is to say, or the husbands of his daughters, were not his dependents, and to any extent that he had provided for them during his lifetime, it was as a result of his love and duty towards his children. So in this way, Charles Njonjo managed to protect his estate from ever being the subject of divorce proceedings. As we discussed earlier, another type of trust is a living trust. So this trust is created during the lifetime of the settlor. And the characteristics of this trust is that it can be revocable. This means that whilst you're alive, you may still decide to amend the trust deed, either to change the beneficiaries, to include more, to remove some, or you can even choose to change your trustees. Another feature of this type of trust is that the settlor can also be a trustee. So you are not only the settlor, but you're also the trustee. So you can still manage and control the trust property. You can also remain a beneficiary of this trust. So any income that's generated goes to you as a beneficiary and any other beneficiaries that you may want to name. So what is really great about this living trust is that it lives beyond you. So although you've created it while you're alive, in the trust deed, you may also dictate that you want for this trust to continue to run with the same trustees and to benefit the same beneficiaries upon your death. And in that way, there's a seamless transition of management of your assets and distribution of income. Another great feature of a living trust is that it bypasses the probate process. Because it was created while you are alive, that trust does not need to be the subject of any probate or succession proceedings in court, unlike a testamentary trust when it would have to be subject to the probate process as the will is being validated. Another advantage is that, as we had mentioned earlier, people usually come to court to claim reasonable provision under estates. In the event that you pass away having a living trust, nobody would be able to claim reasonable provision under your estate because that would then be trust property. And I think the most important feature of this type of trust is the ability to retain confidentiality and privacy. So I know we are all familiar with cases in the news about the estates of very wealthy Kenyans. And once a matter goes to court, it becomes public record. And in that point, the wealth, the extent of your wealth, and any conflicts within your family become, news. And so I think if you would like to retain some kind of privacy and confidentiality, a living trust is one way to do that, because this matter would ideally never get to court and any assets that you have would never have to be declared. So despite all these advantages, there are some drawbacks to creating a living trust, mostly related to cost. Because of the complexity involved in creating this type of trust, you would have to engage the services of a professional. This would be legal counsel, tax experts, and the like, so that they could advise you on any payments that need to be made, and just structure it in a way that benefits your beneficiaries and ensures that the trust will be running well. There would also be administrative costs, which are associated with having trustees. These, as I mentioned before, trustees are managers. So in this role, they are running, they have a fiduciary duty, and they are using their skills and professional knowledge. And so they would have to be compensated in some way. So this cost could come from the trust property, but that is another expense that you would have to consider. And so the trusts that we've mentioned before, these are all trusts that are created by the set law. However, as mentioned before by John and Claire, under intestacy, there are trusts that are created by the operational law. One such trust is the continuing trust, which is created where the beneficiary is a minor. And so in such an instance, the property which is to devolve upon the minor will be held in trust for them until they are 18 years of age. So having said all this, if you're considering setting up a trust, you should consider which trusts, based on all that you've discussed, is suitable to your circumstances. Is it a testamentary trust? Is it a living trust? Is it a discretionary trust? Is it a non-discretionary trust? It's important to consider your family circumstances and what would be most suitable to you. It is also important to ensure that all your documents are in order, because this involves the transfer of legal rights. Your ownership documents such as deeds, logbooks, all such things need to be in order. You also have to consider who will be the intended beneficiaries and who will be the intended trustees. As mentioned before, trustees have a fiduciary duty. They play a very important role. So it's important that the person that you select as a trustee is someone who you trust and someone who you believe has the right skill set to manage your properties, and also someone who wants to be a trustee, because there are instances where some people are not interested in that role. So it's important that you identify someone who's interested in also doing that. And finally, it's important that you consider where your assets are. So because the law governing trusts in Kenya is the Trustees Act, but any property that is outside of Kenya and outside this jurisdiction may not be subject to that act. So it's important that you consider where your assets are and how this affects the structure that you would then use. Yes, so that's trust. Over to you, John.
Thank you for that. So now we'll go into, I note that the time is 12:33. We wanted to end at 12:30, but we shall perhaps allow for 15 minutes of Q&A so that we finish at 12:45 and break early enough for lunch. And so we'll go through the various questions which we have been coming in, and thank you so much for the questions, and we shall answer them randomly on the desk from where we sit. Starting with question number 1 by Ben Mugi. He asks, on jointly owned property, does the doctrine of survivorship apply also to movable property, specifically joint bank accounts? So I think I'm the one who spoke about the doctrine of survivorship. And so the question is here is joint bank accounts. Number 1, I think your guiding document would be the mandate, the mandate that you set up when you are setting up this bank account. What does it say in the event? So bank mandates themselves would be self-executory, so that if the mandate says so and so shall assume full control once one or the other passes on, then that will apply. But the other way to look at it is what is called trying to ascertain whether or not this asset was jointly owned. So there's something is a bit complicated or convoluted. It's called considering the 4 unities of title. So you consider unity of time, unity of interest, unity of title, unity of possession. By and large, I can just summarize it. If you can't ascertain within that joint property which part of it is mine and which part of it is somebody else's, then the likelihood is that that jointly owned property is indeed jointly owned, such that the surviving owner would take up full ownership. The next question is by Ebeluchuku and Neda, who ask, please explain the grant, the bonus, non-intestate again. Please give example of unadministered trust. So this type of grant is where, as I indicated, that you are appointed as an administrator, but before you finish your job, meaning that you've not perhaps paid out all the debts, you've not transferred properties to the beneficiaries. Essentially, time has caught up with you before you've carried out that function. Then this type of grant allows somebody else to come in for the limited purposes of seeing out whatever it is that has been left unattended to. So that is the purpose of a grant, the bonus, non-intestate. Then does a limited grant, and this is Brian Whitty, you ask, does a limited grant ad colligenda bona allow the grantee to access money in the deceased and pay school fees? Perhaps, Judge, you could give the example, practical examples where you might have come across this application.
Yes, this is where, as explained earlier, there has not been a grant of representation, either limited or otherwise, but there is an urgent need for providing for something urgent, and you pick the school fees. Now, that application can be made and will be granted if sufficient reasons are given, because these are things that must go on despite the death of a deceased. Eventually, when the grant is given, then that aspect of the grant is also taken into account.
Thank you. Thanks for that. Yeah, Claire, perhaps this one is for you. What happens if you have an oral will that is recorded by video, possibly even shared in a family WhatsApp group, but the same does not qualify for the 3-month threshold? Is it dismissed despite it losing its termships?
Yes, Ian Bahati. According to Section 9 of the Law of Succession Act, the only exception where an oral will can still be held to be valid post 3 months, is if the testator was, for that period, in active, was a member of the armed forces and merchant marine service. So there are no other exceptions. So all other oral wills must abide by the 3-month deadline.
And the other thing I'd like to mention on this idea of video, remember, if you're capturing something in video, you still need to satisfy the requirement of witnesses. So that video better be clear as to who's witnessing this oral will, so that it actually qualifies as an oral will valuable. So if you take a video by yourself and you're saying an oral will, and you're not showing who is witnessing you, then that will not qualify as an oral will. Mary Wanga, you ask, are we required to apply for a certificate of grant within a given time frame? Assuming letters were granted in 2018 and up to now, no certificate of grant has been obtained, is the letter of probate still effective? So I think to this, what the timelines provide for the earliest period within which, so it says you cannot apply for confirmation of grant before the lapse of 6 months, but there is no outer limit provided. And I think it's a good thing that no outer limits are provided, because sometimes, generally speaking, because of the practical difficulties, you might not be able to gather all the assets of the deceased in order to then distribute it. So the longer time you take, perhaps the assumption is that you then get a greater degree of bringing in the assets of the estate. But yes, there's no time frame set up that such that if you did obtain the grant in 2018, you can still move even now and apply for confirmation of grant. Yeah. Mary, again, you ask, where 3 people have been appointed administrators of an estate of the deceased who died without a will, can these 3 people enter into a valid legal transaction to transfer the property of the deceased whose property is still in the deceased name? No certificate of grant has been taken out. Are we able to transfer the property without full grant? What are the dangers where full grant hasn't been taken out? So number one, if there's no grant, if there's no full grant, authorizing the people set out in that full grant to come in as administrators, whoever who is purporting to deal with the property of a deceased person is committing an offense called intermediate. And as I said, you can be jailed up to 1 year for it. It is quite severe. But let's assume there is a grant, and what you're asking then is there has been no confirmation of that grant. Then similarly, in such scenario, unless you have a special leave of court, and you can approach court under the rules and ask for special leave or special consent in order to deal, then you then don't have power to, because you would be in effect dealing with the property before it comes to the stage of dealing with the property. So I would advise that you await the certificate of confirmation of grant to be issued, and then deal with the property as per the schedule of that certificate of confirmation of grant. There is Jacqueline Oyo who asks, and this is perhaps to Claire because it talks about residual estate. How exactly are those assets distributed?
Yeah, so Jacqueline, in the same manner that assets in a will are so specific as to who they should go to, assets that fall under the residual estate are also very specific. Giving an example, you may say, so let's say you provided that your property shall go to your child. You provide in the residual estate clause, if your child predeceases you, then if they will be married, then that property will go to their spouse. If they will not be married and they will have children, then that property will go to their children. If not, then you provide for all scenarios that can happen such that there is no loose hanging end as to where does this property go. So a residual estate clause is also very specific as to what happens and to who, and if they're dead, who, if they're dead, who, in that, and so forth and so on.
Thanks for that, Claire. The next question is from Bernice Kiso. She asks, what happens if the deceased person made an oral will but does not die within 3 months? However, goes into a coma for over two years and dies later. This means that the will not be converted to a written will within that period. Will the oral will remain valid? I think Claire has already answered that question in the preceding one. But perhaps Claire just to emphasize it because it's the fact that it's being asked frequently means it's a pressing issue.
Yeah. So if the 3 months lapse, then another oral will needs to be made. Remember, capacity has to be made, and then it has to be in front of 2 competent witnesses. And then, so you have to either keep making an oral will or simply then draft a written will.
Thanks. Then from the explanation of gift inter vivos, would giving car keys alone during the lifetime qualify as a gift? Certainly not. Every day I give my wife the keys, I hope she doesn't think I'm giving her a gift inter vivos. But the point here is that you need to perfect. You need to give the key. You need to show you don't have a spare key. And you need to transfer the logbook to the person and part with possession of the key. So the idea here is to ensure you perfect that gift as much as possible. What is the import of Section 10 of the Law of Succession Act? And perhaps you can just have a quick referral what that is, a proof of oral will. So clear this again is your area. Does it mean that there would only be need for independent witnesses to attest an oral will when their accounts of what the deceased said are in conflict? Or should there be an independent witness in addition to the 2 competent witnesses?
So section 10 provides if there is any conflict in evidence of witnesses as to what was said by the deceased in making an oral will, the oral will shall not be valid except so far as its contents are proved by a competent independent witness. So that is like the umpire who breaks the tie in the event that there is a conflict.
Thank you for that. The next one is the Kaluma proposed amendments to the LSA, and the final section amended. The Kaluma, perhaps we'll come back to that. Allow us to just quickly go through the Kaluma proposed amendment, and then we shall attend to that in due course. Could you touch on billing in regard to will? So, I think billing really is a preserve of the advocate that's concerned. Different advocates will bill differently. And so that I think would have to be a conversation between a lawyer and the client concerned. Then the next question is, if the deceased has left behind no spouse, but children who are of age, then is it automatic that the children will get, yes, it will get their estate? And yes, you know, the thing with the law, once it provides, and there's no second guessing. There's no saying, why is it like this? Is it unfair? So the law is very clear on injustice. If there's no spouse, but they are surviving children, those children get the entirety of that net estate equally. So it is equal, and it is the entirety of the net estate, and it doesn't go to anybody else. Could
they still have to go through the courts? Yes.
Yeah, absolutely. Yeah, I mean, so judge, perhaps.
Yes, you're right. There is a further question there. Do they still have to go through the court? Yes. After somebody dies, it's the court that comes in to speak for that person by issuing orders to whoever will represent the estate.
Always remember the guiding rule that absent a grant of representation, either a grant of probate or a grant of letters of administration, you cannot deal. Well, you can, but you'll be intermeddle. And if you intermeddle, you can be jailed. So remember, it is illegal to intermeddle, which means you are dealing with the state without authority of law. Now, perhaps we won't be able, the questions are so many, but thank you for them. But because we said perhaps 15 minutes to allow people proceed for lunch, I will allow Madikizela to address one or two questions there.
Yeah, just going back to Borowako's question, can you please enlighten us on the Kaluma proposed amendment to LSA and the final section amended? So the Act proposed to amend Section 3, which defines wives, to include a spouse, which is then defined as husband or wife or wives recognized under the Marriage Act. It also seeks to repeal Section 29 and include an amendment that says a person not named in this section shall not be a dependent for the purposes of this Act unless the person proves maintained by the deceased for a period of 2 years prior to the deceased's death. So I assume what it was trying to do was to cure the mischief of various wives and other such dependents that tend to appear upon the deceased's death. So I think the import of this would be, it would have a significant effect on that issue that we tend to deal with in intestacy of who is a wife, because it actually provides a definition and it says a wife or wives recognized under the Marriage Act. So I think it would be a useful amendment if it is adopted. Yes.
So I think the last question we will take is a very, hot topic, controversial topic, and for that purpose, I'll open it up to all the speakers to chip in as they wish to. And the question is this: what amount? It's by Mercy Munya. What amounts to a former spouse? Is a divorcee considered a former spouse, or is it only separated spouses who are considered as former spouses? So I'll open it up to speakers, starting with Judge.
Well, yeah, it's a sticky question. I don't know whether there has been a legal interpretation of that, but in a will, one can decide not to bequeath anything to a divorced spouse. But in intestacy, a former spouse, I think, can come in for consideration. I think when you look at the Ngengi Muigai case, there was one of the wives was divorced from the deceased, and we gave provision for a lifetime interest. She died, of course, before the case was over, and the interest went to somebody else. But in that case, there was a former spouse divorced, but then there was a life interest granted. I think, but it's still debatable.
Discussion. Claire, what's your view on that?
Yes, so I think divorcees, former spouses, I have seen authorities where divorcees have applied for provision, even where a will excluded them, and even where they in instances of intestacy. And the question really would be that is yet to be addressed by our courts comprehensively is whether after divorce, was matrimonial property distributed such that then this issue of applying for provision is after they got their contribution. So that's what has not quite been adjudicated by the courts extensively. But to answer this question, is a separated wife divorced, both of them are former wives as far as the Law of Succession Act is concerned.
So for me, I think I'll answer and say it depends on who I'm acting for. No, but no, I think a more honest answer is the act as framed. The act as set out states former wife, and it does not exhaust that definition. So a liberal interpretation would allow for a divorcee to be interpreted as a former wife, which is what is called a literal interpretation. I have seen some scholars, Musyoka J included, who say that in his opinion, a divorcee who has attained his or her settlement under divorce proceedings and has taken whatever it is that is due to them cannot surely come under succession and claim a second time. But if my thinking was, if it was that clear, then perhaps the act would have said as much. So why did the makers of the law leave it at large? I think it's just to allow for my wives to come. So I think it is the questions that keep coming in, and thank you, but we can't take all of them. It is others will be here for too long. But I just saw one question, which I think is an important. The question was, what is the maximum number of persons who can be administrators? Because that is set out in the law. It prescribes 4 as the maximum number, and actually 1 as a minimum, say for estates where there's a minor involved, in which case it has to be 2. So it is 4 as a maximum number, and 1 or 2 as a minimum, depending if there's a minor involved in the estate. So that brings us to an end, and I thank you all for the comments. We shall look at them and perhaps do a write-up and share it on our insights page that covers the FAQs, frequently asked questions, and we shall then share it to everybody who attended this. As to whether or not you'll get the slides, I will ask that you do reach out to our insights team at insights@oraro.co.ke, and they will be able to deal with your request. So thank you very much for having spent this past 2 or so hours with us. It was our distinct pleasure to share our views with you. Asante sana.